co-moderators of this session, who are Ila Kapoor of SAM and Manish Agarwal of Three Crowns. Thank you.
Thank you, Gautam. Good morning, everyone. I'm delighted to introduce our panelists. My co-moderator for today is Ila Kapoor, who's a partner at Shahadullah Machand Mangaldas. Rahul Narayan heads disputes practice at Chandiok and Mahajan. To his left is VP Singh, who's the head of AZB's litigation practice here in New Delhi. Anish Wadia is an independent arbitrator, mediator, and adjudicator. And Lucy is a counsel at Reed Smith. We are delighted to have you with us. I'll hand over to Ella to kick off.
Thank you, Manish. And welcome everyone to our panel on the state of play of investor-state arbitration, a view from India and elsewhere. Now, in India, we cannot have a panel like this without starting with a reference to white industries. This, as we all know, is the case which had the first adverse award against India. There was a lot of concern about what this would mean for the exchequer. And India started adopting a very state-centric approach. In 2016, they terminated 58 of their investment treaties. And I believe in the next few years, they tried to terminate 19 out of the 25 treaties that were remaining unilaterally. In 2016, they also adopted a model BIT, which they have tried to use to renegotiate their investment agreements with other countries. Now, the model BIT, some would argue, is very state-centric. There are a number of provisions. So the definition of investment is much narrower. Clauses such as the most favored nation, the fair and equitable treatment, these have been removed or narrowed. And what, in my opinion, is the most concerning is that they have included mandatory exhaustion of local remedies as a precondition, which in India may be seen as problematic for a foreign investor who wishes to go into investment arbitration. So my first question for our panelists is going to be what they think about this model BIT. But before I ask this question, I'd like our audience to show with a raise of their hand if they are in favor of the model BIT as it currently stands. So if you're in favor of it, can you just raise your hands, the model BIT? Okay, let's see if you're just being lazy. If you're not in favor of it, can you raise your hand? Okay, so I think VP, unless you can convince this audience otherwise, go for it. Tell us about the model BIT.
Thanks, Ila. Let's put it this way. No one can say that India is investor unfriendly. History shows that we were so friendly to our investor that we gave up 100 years of our independence to it. Therefore, let us start with why is it important that we find a balance? And does the cookie cutter model of the first model that we had, which was the India-UK bilateral treaty, become the model for all times to come? My short answer is we should take back for butter chicken what we gave up for chicken tikka masala. And the answer to that is simple, straightforward. Look at a model which allows for you to deal with the world on equal terms and avoid being called out for the same flaws or the same faults that you called out your treaties on. So when we deal with a state of play and the state of play that the model BIT brings about, the idea is equalization. And it's equalization for a good reason. You deal with giving everyone access on terms that you will yourself take access on. Having gone to the parliamentary panel which looked at the model BIT and its revision, the one thing was very clear. They said that, so my plea to them was, I had gone on behalf of industry, that we are going to challenging nations. We are now a capital exporting country. And we are going to areas where we will face challenges, due process, access to justice. And they said that we can't allow for our people to be treated separately from how we will treat others who come into our country. And as a result of which, they said that there will be no exclusion or disparity of terms where we are a capital exporting country and where we are capital importing country. The second thing that was very clear was what is bandied about as the regular horse, which says that it hits investment. I just want some numbers to show out. There is no causal link about how it does impact investment. It does help investment. I'm not denying that. The government also says the most charitable view that you can take is there is some correlation, but it's too intangible to be quantified. And the government has good reason to do that. The last 8 years since the treaty dissolved, or 77 of them dissolved at least, have been the 8 most highest FDI years for India. And I'm not standing here as a poster boy for the government of India. I'm saying that there is no correlation that seems to indicate that the existence of a treaty protection facilitated for India investment into India. And if I were to break it up, when all these treaties were there, you didn't have the same level of investment. So what makes it a simplistic black and white may not be correct, that if there is investment treaty, there is investment. And our government, I think, has taken the right step of trying to equalize or at least calibrate its approach towards investment treaty. And this approach is not out of whack, incidentally, with what you would consider to be the approach of the world. Take a look at the Singapore-Indonesia Treaty. The Singapore-Indonesia Treaty creates similar carve-outs. Fair and equitable treatment is, fortunately, not as fair as the previous draft would want it to be. Similar in terms of language and structuring to the Indian treaty. Of course, we do away with it altogether. We go to manifest denial of due process and we talk about abuse. The second thing is they also have a calibrated approach to MFN. And the last piece is taxation is excluded. So how are we out of whack? And if that is the case, the idea is, as the sun set on the empire, let a new sun rise in Asia and let the model BIT be that sun.
Thank you, VP. I mean, you talked about how, we don't want to treat the investor in India differently from the Indian investor. But, wasn't the whole point of these treaties that we insulate the foreign investor from the vagaries and the systems and the ad hocism sometimes of national jurisdiction? And that's why they want to come in. We want to uniformize it for the foreign investor.
Investors come in because they see opportunity and they price risk. They price it in. Obviously, where it's too risky, they don't come in. We've seen in the last 8 years, the risk definitely is priced in and has been priced in with the 5 most bumper years of FDI. And this includes the post-COVID period.
Anish, do you have any thoughts on this?
Yes. As VP in his usual charming way will try and showcase, try to showcase how, India is on the right track. But precisely for that 100-year example he gave, we need to be very cautious about this. And I think we're putting the cart before the horse. Today, and the best example I could potentially give you is we're trying to make a very simple matter, very complicated, sounds sexy, investor treaty, ooh, wow. But in 2018-19, the CEO of Hong Kong, when she talked about in her annual report, the need to bring about Belt and Road specialized centers to deal with Belt and Road disputes. And the best corollary I could give with that and the argument VP was trying to advance in terms of India having a model BIT is today, 50% of our battles are won or lost in terms of if you have an existing infrastructure well put in place. Similarly, rather than what they were seeking to do in Hong Kong, and when a lot of people talk about having specialized centers, specialized XYZ, in terms of the Belt and Road Initiative, rather than talking about having specialized centers, people could very easily adopt the UNIDROIT principles or the CISG, and 50% of your issues would be resolved. Today, when we talk about having a model BIT, you cannot, and it will never work, to have a model system applied to the whole of India. Never going to happen. Mark my words, this is being recorded. For several reasons. There are sovereignty concerns, okay? There are, in a country as diverse as India, you cannot have a uniform system to deal with all sectors, whether it be oil gas pricing, whether it be the agricultural sector, because how entities in Europe would deal with agriculture would be very different with how we treat it, right? Similarly, if you look at, let's say, the OHADA countries, if let's say we have a model BIT and we want to enter that into with any of the OHADA region countries, now OHADA in its arbitration regulation and regime very clearly defines an arbitrator, for instance, as someone who's a natural person. So if India suddenly wants to talk about AI in arbitration, that would never work in a model BIT with any OHADA region country for this reason. There are other various legal complexities involved. See, today when you talk about enforcing model BITs in India, the existing infrastructure isn't there. So why do we talk about, yes, let's have this model BIT, sounds amazing, investor protection, yes. Okay, let's say we have a model BIT, they win an award, what do they do with that? Other than fan themselves with that piece of paper that they have, right? They're going to run around in courts, make the system of taking that money, taking it out of India a lot easier, right? I think that's perhaps where our focus should lie, build the capacity. And not only that, but today, 2 points. Having a mechanism of enforcement, like we have specialized judges dealing on commercial benches, similarly have specialized judges dealing with investor treaty who have the know-how, the expertise, the training in dealing with these types of disputes. And number 2, in building that capacity, build the capacity not only for the enforcement mechanism, but the people using it in their contracts. Because today, how many times in-house lawyers, people actually drafting these terms and agreeing to enter into agreements with various companies, entities, they don't understand the implication of this, right? So those are my initial thoughts.
Thanks, VP and Anish. Rahul.
I have actually one quick comment. As a matter of principle, it's great that India is using its experiences to negotiate a new BIT, but I think that we should not let fear guide us. I think the sad reality of India, independent India in international law has been persistent fear that we might lose. The only proper adjudication which has taken place involving India and a foreign country, I think, is the India-Pakistan Indus Water Treaty arbitration, which took place in 1960, which we won. But we were so petrified of losing ever since then. We have a lot of reservations in the ICJ, for example, and we continue the same approach over here. I think that you win some cases, you lose some cases. It's important to change guidelines to make whatever works for us best, but we shouldn't be guided by fear. We should be guided by opportunity. And the fact that we are now a capital exporting country means that we needn't put on the same old hat of fear and protectionism which guided us for so long in the past.
Thanks. So that's a very nice segue into my next question. As we know, many of the terminated Indian treaties have a sunset clause. A UK investor has already invoked that clause to sue India. And the question that many have been pondering about is India going to seek to agree with the state counterparties to actually terminate the sunset clause itself? And if India were to do so, how might the investors respond to that? May I bring in Lucy on that discussion?
Thank you very much, Manish. So I think if you'd asked me this question a few years ago, I would have said, no, absolutely not, impossible. As you'll be well aware, the entire purpose of a sunset clause is to ensure that investors who have made investments in reliance on those clauses continue to be protected even after termination. And, we've seen that this has worked in practice. We've seen, in addition to the claim against India, which Manish referenced, we've seen claims against states such as Romania and Tanzania, even after the relevant treaties have been terminated. But I think it's really fair to say that the landscape has changed, and we need to look, I think, to what's been going on in Europe more recently vis-a-vis intra-EU BITs for some broader context. So since 2016, India has terminated, I think it's 77 of its BITs. Now, arguably and legally, the time for dealing with the sunset clauses was prior to termination. We're all aware that in principle, states can agree to amend their BITs, and in principle, India could have made an agreement with the relevant states to terminate those sunset clauses or remove them from the treaty prior to termination. And this is what some of the EU member states have been discussing, and there's also precedent for this. Denmark and the Czech Republic did this in 2011 before terminating their BIT. More recently, Indonesia and Argentina. And Norway and Latvia are actually apparently discussing doing this right at this very moment. But India didn't do this prior to termination, although please jump in if I'm wrong. But my understanding is they terminated all of their treaties unilaterally without kind of seeking this prior agreement. Now, obviously, removing the sunset clause is something that has to be done mutually and by agreement. And many of the state counterparties to the relevant BITs would likely not have agreed to this. But there are some where, and I'm purely kind of hypothesizing here, but there are some where you might expect that there could have been some wiggle room for agreement. So Belarus is one example I have. The 2002 treaty was unilaterally terminated in 2017, but the parties went on subsequently to agree the text of a new treaty, which is much more state-friendly. So I don't know, but I would have thought there might have been scope there to have removed the sunset clause prior to termination. And the India-Indonesia BIT is another. So Indonesia was even ahead of India, really, in announcing its intention to terminate all of its BITs. That was back in 2014. So it's possible that they might have agreed to remove the sunset clause prior to termination. But this wasn't done at the time, so the question now is, well, where does this leave India now? We've seen what the EU is trying to do in its termination agreement, which is to remove the effects of the sunset clauses in all intra-EU BITs, including those treaties that have already been terminated, and despite the fact that post-termination, those sunset clauses are now operational. Now, the specific arguments for this in the context of kind of the EU termination agreement are very specific, and they relate to illegality under EU law. So they're not going to be applicable here for India. But I think the broader intention is, of course, the same, and the effect on investors would be the same. So how might investors respond? Now, I think we need to think about this from at least two different angles. When we talk about India and its evolving approach to BITs, the focus is often on claims against India. But that forgets, and it's something that my panelists have raised this morning, that forgets that there have actually been around 12 public and possibly many more claims brought by Indian investors against other states, because India is now very much a capital exporting country. That's not as many claims have been brought against India, but it does show that Indian investors are out there relying on the protections in investment treaties. So if India were to do this, and I hasten to add that there's no suggestion as far as I'm aware that this is in contemplation, but it has potentially serious ramifications, not just for inward investment, but for Indian investors as well. In terms of how inward investors would react, and now I'm going to say something a little controversial here, because I think Viandra and I have read perhaps different studies in preparing for this panel, and I'm definitely not going to trespass on the debate about the Indian model BIT. It's very difficult to predict, obviously, how this would impact FDI. But there is an interesting study from 2022 which did find that India's termination of its BITs did impact FDI negatively. But it also found that there was a rerouting of FDI, particularly in the context of M&A and buyouts. So I'm not saying that it would necessarily cause a drop. There may just have to be some kind of rethinking around it. And I think we would see more of this in circumstances where sunset clauses are terminated. Because, of course, right now, in post-termination, investors are investing in reliance of this, with the sunset clause. So there's also, of course, the issue of pending claims. There are currently, as I understand it, at least 5 claims pending, some of which brought under sunset clauses. My personal view, Chatham House rules, is that investment treaty tribunals would give pretty short shrift to an attempt to retroactively terminate a sunset or retroactively remove a sunset clause, particularly in connection with a pending claim. But of course, that would be a great concern to investors who do have claims pending. And then slightly more abstract, but also very important, there are obviously very serious implications going to respect for rule of law, which I think are important. retroactive termination is very much at odds with the purpose of these clauses that I outlined at the beginning. And the idea that the offer to arbitrate is irrevocable, and that constitutes a general principle of international law. So I think efforts to undo that have serious ramifications for the kind of international legal community.
Thank you, Lucy. In fact, there is, one case where an Indian investor has brought a claim against Mozambique 15 years after the termination of that treaty under their sunset clause. And as you said, we're going to see and look closely to see how arbitral tribunals are going to deal with these cases if India tries to unilaterally terminate the rights which are vested under the sunset clauses. And I think I agree with you that arbitral tribunals are unlikely to look favorably on any such attempt. But, we've been talking a lot about competing interests between the state and the investor. And this is a good time to have a think about anti-arbitration injunctions. We've had cases which have come to the Delhi High Court in the Vodafone case and in the Khaitan Holding case, where the Union of India tried to stop the investment arbitration that was being conducted against India outside of India. And in both these cases, the Delhi High Court said, well, they're not going to pass this injunction. Rahul, what are your views on these sorts of anti-arbitration suits?
Let me put it like this. There's a little bit of irony in the Indian approach to anti-arbitration injunctions, particularly when it comes to investor treaty arbitration. The fact is as follows. In India, investment treaty arbitration is a very strange kind of beast. It's arbitration, but not under the Arbitration Act. It's not really a civil suit. So the fact is there is no real mechanism at this point of time to either enforce the arbitration award once it happens, or even to assist arbitration when it takes place. So when these claims first came to various high courts, the first high court which dealt with this was the Calcutta High Court in Louis Dreyfus's case, where they didn't decide the issue whether the Arbitration Act was applicable or not, but they decided to go ahead and grant the anti-arbitration injunction. I think it may be the only case in India so far where such an injunction has been granted. Now, since then, the much more considerate Delhi High Court judgment in Vodafone in 2018 also got into this in some detail and decided that, let me start with a small introduction as to how it works elsewhere. If you sign the Exit Convention, you can enforce an award anyway, and of course, the arbitration takes place under that. If you haven't, then for every other country, the New York Convention is the governing law. Now, when India signed the New York Convention, we made an exception for what India calls non-commercial disputes. If a dispute is non-commercial, it's not governed by the New York Convention. Now, the finding of the Delhi High Court was that an investment treaty arbitration is not commercial because it deals with issues of public international law. Therefore, there was no real jurisdiction under the arbitration law to grant this injunction, but after a fair bit of hemming and hawing and looking at international precedents, particularly an interesting precedent from Belize, the Caribbean Court of Justice, they decided that they did have a general right to grant an injunction if the arbitration was vexatious and oppressive. Again, the fact is that the irony, of course, is that in those particular facts, they decided that the case wasn't, the arbitration wasn't oppressive and vexatious, and the issues that were raised should be decided by the arbitrator under the old principle of competence. So it's still arbitration for deciding that. But so the courts have decided then, therefore, that they can grant the injunction, but they haven't really done it yet. So this is, you can call this a kind of Marbury versus Madison moment for anti-arbitral injunctions. You have the power to do it, but you're not actually going to do it in this case because it's not politic. And also, I guess the lawyers would call it Operation Successful, Patient Dead. So you make this wonderful case and everyone says, yes, you can grant the injunction, but you're not going to get it. In my opinion, of course, that's the way it should be. You shouldn't grant arbitration injunctions easily. But again, the irony again remains that in normal international commercial arbitration, which is done under the Indian Arbitration Act, exactly the same approach is followed. So we have very few anti-arbitration injunctions that are granted, and pretty much on the same grounds as they would eventually be granted under this.
Since you may have a contrary view.
So my view is very simple. Try and seek an anti-arbitration injunction from the Delhi High Court and you see what your chances are. Gone are the days where you would have skepticism. Now you have hostility. So first you have to explain why such a plaint has been filed. And that is the standard that we use for commercial arbitration. Yes, Rahul's right that there is a strange beast. We don't know whether it's man or animal. But the same dispensation would equally apply there. However, when it comes to dealing with international commercial arbitration, the Indian mindset is a lot more innovative. It's entrepreneurial and coming up with solutions. So what we do is we try and hit it in other ways. One such way was when Devas was being heard, the commercial arbitration, not the VIT. The tribunal had been constituted, incidentally. The government had actually nominated its nominee. They filed a Section 11 in the Supreme Court saying, well, we didn't understand what we did. We want you to come in because there's a default and they can't appoint the third person. When a third or a presiding arbitrator had been appointed. In the course of the 11, they got an injunction from the arbitration sitting and continuing to be heard till such time as it was decided whether the chairperson had been correctly appointed. So for an Indian mindset, we no longer seek it in a plaint. We seek it in innovative ways. The second place that you saw that happen is in the Devas matter where you just saw why take care of the fruit when you can get rid of the root. They got rid of the company. As a result of which, you suddenly had a victim that did not exist. And you had a derivative claim which would be dodgy under Indian law. And you had enforced a system, an amendment which was effectively not applicable at the time when the award was passed. So the idea here is today Indian courts may not grant you the anti-arbitration injunctions, both for commercial or investment arbitrations. But the Indian mindset finds answers around them, either getting around the root and fruit theory or by ensuring that there are other ways in which one of the clogs in the wheel can be taken away. Last but not the least, I think we've learned our lessons. As Rahul says, we come from a position of fear. We've come from a lesson where, and I see people here who have done it. I think Gautam, you did the first one that actually went into a BIT, and Shreyas did one which is the last award effectively. And between the two of them, there's been a huge change in mindset in the government. The government moved from paying awards to contesting awards. So today, all is fair in love and war, as long as it does not disturb what one would call is the federal budget. Because the government is genuinely worried with $1 billion to be sprung out of somewhere for a decision that it had no hand in. And you can find this fear set out in as many words in terms of the report that they have issued. So what does the government do instead? It now fights these claims much more robustly. It fights them across the world and is now trying to build up a capacity to deal with these claims, both at the stage of injunction, including arbitration injunctions, as well as at the stage of enforcement. Because at the end of the day, it ain't over till the fat lady sings. So I don't see the government paying up awards like it did in White, and I see the government actually contesting them more.
Thanks, VP.
Just before, so because I don't like VP having the last word always. All's fair in love and war, but we're talking about the rule of law. So it isn't all's fair in love and war. The government also has to follow the treaties that they sign and the agreements that they make. I mean, one could argue that.
The government does believe it is following them, but it believes that the concept of ad idem and consent should move from deciphering consent, as the investor claims, to what they say is the case, which is manufacturing consent, because consent is vitiated on account of corruption. It's a thin line. You can choose on which side you have to be. Unlike me, the line's quite thin.
Let's move from that controversy to another. Are there any representatives of third-party funders in the audience? We do. Then you might be interested in what is said in the recent report of 8th February 2024 by the expert committee, which actually advocated for a separate legal framework in India for dealing with issues arising from investment treaty arbitration. Among other things, the report raises concerns about the use of third-party funding in the context of investment treaty arbitration. And this is what it says. The question of third-party funding in BIT arbitration raises important questions affecting national interests. The Arbitration Act was amended in 2021 to deal with awards procured by corrupt means. Viewed in this context, if third-party funding in BIT arbitrations is recognized in India under the present law, it may facilitate the assignment of awards won by corrupt means by the successful party to the third-party funders. This will result in successful parties walking away with their ill-gotten gains, leaving the government to engage in litigation against third-party funders. Anish, could I bring you in and on this, and could you share your views on?
Yeah, I think that's an incorrect characterization, with great respect to everyone involved, hint, hint, in preparing that report. Number one, we must realize third-party funding, not alien to the Indian system. The concepts of champerty maintenance, just to give a little backdrop, from 1876, perfectly does not apply to India, affirmed by a constitution bench of 5 judges of the Supreme Court in 1954. Litigation funding is permitted through amendments of several high courts in the CPC. So this is not an alien concept to India. And of course, a 2023 decision of the Delhi High Court also supporting this view, right? So we must first move away from thinking third-party funding is alien to our system. Number two, to say that investment treaty arbitration because of third-party funding would affect national interests is an incorrect statement, for the simple reason, by that same logic, it could also affect national interests in a commercial dispute where third-party funding was utilized. Because let's say today you go against a state entity controlling oil, gas, right? That contains national interest. A third-party funder could have a commercial claim of, say, $500 million US against a state entity, use a third-party funder. Technically, that too would apply and affect national interest. So that would be an incorrect classification that investment treaty requires special consideration because third-party funding, corruption, I think that's misconstrued, and which is, again, I go back to the base. VP spoke about earlier, and Rahul was also saying about, investors must feel that they're being treated equally. The question is not treating equal parties equally, but the question is, only parties who are not at equal footing to be given the same treatment. That is key. That cannot be achieved by having a uniform one-glove-fits-all policy. Okay. My other concern in the committee's report, I hope it doesn't go to that extent, but I quite like the introduction of 18A that they're proposing, where disclosure is required by the party. My concern with having that is, for any of you who are from Singapore, I don't want the Bar Council of India to take lead from that and then take cue from what Singapore has done by making it a statutory requirement for any Singaporean lawyer under the Legal Profession Act to disclose, even if they are aware of their client adopting third-party funding. Because what then happens is, which is why today, if you look at statistics, the amount of Singaporean qualified lawyers who are representing parties in investor treaty arbitrations is very, very small. Because one of the key thresholds, and we have a third-party funder here, third-party funders don't want their document revealed. They don't want terms of that revealed for several reasons. And in India, the one concern, which again, we talk about introduction of TPF, disclose it, but we still haven't completely worked out how that money would be repatriated. And the other point being, today we say, oh, third-party funding, big issue, investment treaty or commercial. Simply put today, what if a bank, let's say VP borrows $100 million from a bank, uses that, he uses that to fund that amount through a loan, not a funder, through a loan, uses that to fund an arbitration. Is that considered third-party funding? You see, so we must be very clear, rather than trying to introduce new things and plug gaps in, come up with a comprehensive framework to fix what is currently existing, rather than adding more to it and thereby creating a burden on an existing system which isn't perfect.
Thanks, Anish. Another recommendation in the expert committee report is to support the creation of a multilateral investment court. However, and I'll bring Lucy in on that, it was difficult to actually follow the logic of that, because they say while the government should draft a separate law for BIT arbitrations, because BIT arbitrations can't be equated to commercial arbitrations, to make India a hub for international commercial arbitration, an investment court should be set up in the gift city. I did wonder about the recommendation, but Lucy, perhaps you could share with us your thoughts on the proposal to support the multilateral investment court.
Sure, thanks, Manish. Multilateral investment court. So I will personally be surprised if I see this come to fruition during my career, and I hope that there are still some years left of that. In terms of where we are now with the multilateral investment court, so you'll be aware it was the brainchild of the EU some years ago, although it's currently being debated more broadly by UNCITRAL Working Group 3 in the context of its wider discussions around ISDS reform. So the idea broadly is that it would be composed of a first instance court and then an appellate body or an appellate court as well. The court would adjudicate claims brought under investment treaties that member states have decided to assign to its authority. Both of the bodies, and this is quite important, would be staffed by kind of tenured adjudicators who are appointed and also remunerated by the member states themselves, and then assisted generally by a secretariat. Now, there have been a number of sessions where the practicalities around how the multilateral investment court would function have been debated by Working Group 3. The next one is actually coming up just shortly after this session, so in April 2024. And at that session, the stakeholders are going to discuss the kind of revised statute for the MIC, which takes into consideration their previous discussion and stakeholder submissions on the subject. Now, I think in principle that there is some logic to what is being proposed, the idea of a kind of institutionalized body, because you can't deny that ISDS has in the past few years been experiencing something of a crisis of legitimacy. And one of the complaints often raised, and particularly in mainstream media, where perhaps there is a bit less understanding about how arbitration works in practice in any event, but one of those criticisms is that, you know, these huge decisions, these enormous awards against states are decided by secret tribunals behind closed doors. I mean, I actually, in a mainstream British newspaper, I actually read the words kangaroo court, which, of course, I don't agree with, but that is the public perception within, you know, some pockets. Now, this sort of structure, the MIC, that potentially goes some way to addressing these sorts of criticisms and concerns. But I think it's really difficult to kind of sit up here today and give a sensible view on what this would look like in practice when it's still so unclear as to how it would work. So with apologies, I have more questions than answers for you, but some of the questions I have around how it would work are, you know, so if adjudicators are chosen and remunerated by the member states, is there a risk, whether it be real or perceived, of political bias? You know, because even perceived political bias in a system that's predicated on consent is really important for the legitimacy of the system. And there was a study by Queen Mary University about 4 years ago now, and only 27.5% of respondents considered that an MIC with state-appointed adjudicators would be viewed as impartial and independent. And I think we really need to think about that. You know, another question, what does it mean for states who choose not to go down this path? They choose not to include the MIC within their dispute resolution provisions in their treaties, and they stick with the more traditional ISDS model. You know, and we know some states are opposed, the US, Japan, Chile, they've all made submissions against the MIC. Now, this, I think, would lead to even greater fragmentation of the system with a sort of two-tier system and, you know, exacerbate concerns around inconsistent decision-making that we already see. What will the capacity of the system be like? You know, one major criticism of ISDS is that it can be really slow and parties can wait years for an award. And if the idea is that adjudicators are appointed on a permanent tenured basis, well, how many adjudicators will there be? Will there be enough to deal with all of the claims? You know, claims only increase year on year. So are we going to start to see a huge backlog of these types of claims? You know, related to delays and length of proceedings, I personally have serious questions around the proposed grounds for appeal that have been included in the statute. You know, in particular, the inclusion of appeals for errors of fact, and then the sort of shoehorning in of typically enforcement resistance grounds, you know, public policy concerns. I think this is really subject to potential abuse by parties who want to drag out the process. And I think we could start to see, you know, systematic appeals simply just to avoid enforcement. You know, and finally, and, you know, more generally, more abstract, is it a good idea to institutionalize state-to-state dynamics in this way for ISDS? There are, of course, you know, bilateral examples of similar structures that have worked, you know, well, the Iran-US Claims Tribunal being one of them. But look at the, you know, the World Trade Organization as an example of a multilateral structure. You know, the appellate body there has been effectively frozen since, you know, 2019 due to various, you know, geopolitical standoffs. And is there a risk that we'd see the same thing for a multilateral investment court? Now, those are just, you know, some examples of the types of really thorny issues that will need to be bottomed out before this can come to fruition. So I think we're a very long way away from a multilateral investment court.
Thank you, Lucy. And let's come back to what is, I mean, as you said, this is a long way away, but let's come back to some problems that we have with the existing system in India. And I'm going to ask this question to Rahul. As you know, we are not a party, India is not a party to the ICSID Convention. The courts have found that these investment awards against India are not commercial awards. They can't be enforced under the Arbitration Act. They can't be enforced against the Civil Procedure Code. They're not decrees. And of course, then the investor also has to face defenses of sovereign immunity. So where does that leave someone who has an award against India and wants to enforce it in India?
Well, it leaves the investor hanging somewhere in between the law, because there is no legal way actually to enforce this. If you can't enforce it as an award and you cannot enforce it as a decree, how do you enforce it? I mean, of course, the traditional position of law has been ubi jisibi remedium, that where there's a law, there has to be a remedy. You have an award and you don't know how to enforce it. I don't know if there is a mechanism right now in the absence of, there's something in the new BIT, of course, that they say that this will be treated as commercial and therefore it comes under the rubric of the Arbitration Act and gets out of the thorny hole we found ourselves because of our exception to the New York Convention. But until that happens, as of now, there seems to be no reasonable way to enforce an award against India. What parties would do is try to enforce it abroad, which actually is a very, very suboptimal solution. I mean, it would be embarrassing and difficult. It has been embarrassing and difficult for India to contest, actions against, say, Air India in New York or something like that. Now, the traditional position of international law, of course, has been that state assets can't, for example, embassies cannot be attached, they cannot be auctioned or something like that. So how would Indian assets abroad be considered for this? There would be a fair amount of disputes about whether assets belonging to Indian public sector enterprises could perhaps be seized. Although, again, I mean, public sector enterprises are enterprises, they're companies. So the old principle of corporate responsibility and corporate separate identity means that you can't go after, say, the assets of State Bank of India abroad because you have an award against India. So I think it's a tricky position, and this is definitely somewhere where there has to be an amendment to the law.
Thank you, Rahul. And maybe, related to that, how do you think an Indian court would treat a case where an investor was trying to enforce an award against another state in India against their assets?
See, let's be very clear about how we see it. India will give reciprocal enforcement to something which is a money decree. The question comes down to, is this chicken or egg? Because at least a constitutional bench has turned around and said, you can convert an award into a decree and then bring it here to enforce. The problem that I see is, and this is one rule that may be available, if there is no defense available and there is no other route available, if it's an award against the government of India, seek a mandamus for them to comply with the award with a consequential direction for them to make payments. Because you can't ask for money in a writ. Money cannot be your primary relief. It can be a secondary or a consequential relief. So that's how you would try and enforce it in the limited regime that is available. Issues of disputed facts, etc., will get taken care of because there's already an adjudication there. What it does is, while it may not give you a 100% answer, it will get the government to challenge it somewhere. And that's where you would hit it with a counterclaim. Because you can punch, you can't be stopped from punching back. So that's the first thing. Against a foreign government, which is coming to India, we have only deference in terms of giving notices in such a situation. A foreign sovereign is not immune from litigation in India. Yeah. So that's what. So we don't, while we have deference, we don't have an exalted status. And I think that's how we're going to play it out. But it's going to be a while since we have our own around 40 million cases to see someone come to India to enforce against a foreign sovereign. So I'll park that for about 10 years later and we'll have that conversation then.
Just a quick cautionary note to add, because we don't have time to discuss it. The Malaysian practitioners in the audience would know this, but please look up the Sulu case and the Sulu saga that's going on. It's a cautionary tale about how sovereign assets are being attacked and taken over. What's going on in that case in terms of recovering assets in foreign countries belonging to the sovereign, etc. But do look into that. We can have a separate discussion just on that one particular case. But yeah, just as a cautionary tale, please look up the Sulu case.
Very good. Look, we can continue with this discussion. It's a really thrilling discourse, but I'm conscious of time. So perhaps we'll take some questions from the audience now, and then we can see if we need to come back to any of these topics. Do we have any questions?
Surprisingly, this is the third panel discussion on investor-state arbitration in as many days. And I say surprisingly because on the face of it, there's nothing much happening in this space in India. We've cancelled most of our existing treaties and there don't seem to be too many takers for the so-called new model treaty. But perhaps this is an indication from the organizers of this weekend that in the days to come, there's going to be more activity in this space. Now, yesterday's panel discussion, in that they were of one mind that India was headed the wrong way insofar as this is concerned. And some of them actually tore into the model treaty. Today's panel seems to be a little more balanced with Mr. VP Singh seeming to toe the government line and Ms. Kapoor and Mr. Wadia taking the opposite stand. Coming to my question, which is based on something that Mr. VP Singh said. He said, in the last so many years, since 2016, we've had so many millions of dollars coming in anyway, so where's the problem? But then he went on to sort of contradict himself by saying that, you know, they factored the risk into it. So my question is this, notwithstanding that there have been substantial investments in the last several years, had the terms been more favorable for investors, would both the quantum and the terms of investment have been better had it been easier for the investors?
That's a good question. And it's obviously everyone looking at the tea leaves and trying to figure out, was the tea good? But not decipher the future. Because that's all we can talk about. When you look at the tea in this cup, 20 years of seeing the tea saw you to a particular level of investment. when there was a complete protection of 83 treaties. Today, in the absence of 77 of them, a joint interpretative statement on 2 of the 6, which reduces quite significantly the coverage. If you see something go up, at least one thing is clear, it's not a one-to-one correlation. That's the first part. The second part is the selling point, the sole selling point has been there's a direct correlation with investment. That doesn't seem to be made out. There are some surveys, and the good part about statistics is there's lies, damn lies, and statistics. So we have, at least in the model treaty as well, the report says that the government actually did a survey in 2016 to find out whether there was an impact. And the government found that while there may have been some overflow, and it was charitable as it calls it, when it says I can give some kind of a linkage, but there is nothing decipherable. And in today's case, how does, say, the existence of an investment treaty assist with a China +1 theory of recalibrating supply chains? You would look at not investment treaties alone, but you'll also look at viable markets. So the idea here is there is something more complex than investment protection alone. The second piece that I was making out, and you're right, it does seem a little contradictory, but maybe I can explain it, contextualize it. The idea here is that if someone comes into your country to do business, they prosper on the basis of how many times will they be fulfilled in their bargain. If your courts do not assist with getting the desired results in case of breach, you end up with a higher cost of doing business. The ease of doing business is when you invite people, cost of doing business is when you make them pay out. And that may be the reason why people price out markets by saying it's not worth my while. I think that's happening. I'm not saying that it's not happening. But fortunately for us, post the 2016 period, we've also seen a purple patch of sorts. Could it have been more purple, royal purple? We don't know. But at least we can't stop beating it black and blue on the fact that there is no investment treaty. And I think that correlation at least has been put to bed. That's what I meant when I said that there is a need to look at a construct and the new sun will rise in Asia rather than look at a model that came in from the West.
Could I also make one observation? I think I don't agree with the view that because India has terminated most of its BITs and the model BIT has not had many takers, the topics become irrelevant. Actually, a number of our clients are making very significant investments in India across sectors. And the question that people are asking for their new investments is how do they structure their new investments into India to benefit from the protections of the treaties that remain in force? So I think the topic is very much relevant. It is very much on the minds of the investors who are looking at India as a major investment destination. I'm conscious
I think we can take one more question before we...
Thank you.
Hello, everyone. My name is Ankitesh. I have a question to Ms. Lucy Winnington, since you come from a jurisdiction that has signed the Exit Convention, unlike India. So one of the most time-consuming aspects in treaty-based arbitrations is challenge to the appointment of arbitrators on the ground of impartiality and lack of independence. The Exit Convention, if I'm not wrong, allows such challenges on the ground of manifest lack of independence and impartiality. Now, a lot of time is gone into evaluating the standards to be applied to see whether the arbitrators actually lacks impartiality or not. Now, in such a situation, will it be legally tenable for an arbitral tribunal, let's say an exit tribunal, to apply the IPA guidelines on conflict of interest to see if the arbitrator actually lacks independence and impartiality? Or will it be considered as something that the tribunal has traveled beyond the scope of the convention by applying the IPA guidelines on conflict of interest?
Thank you. Just to check I understand your question, it's can tribunals look to the IBA rules on conflicts of interest when determining challenges under the Exit Convention? Yes, absolutely, and they do. The IBA rules are, they're seen as a consensus of stakeholders on kind of general principles. They are not binding, of course, on exit tribunals, but I have personally been involved in challenges where the IBA rules have been considered to be persuasive and where parties, do refer to the orange list, the red list, and arguments are made around that. Just in the same way that parties will rely on, previous decisions of ICSID tribunals interpreting the meaning of, impartiality and independence.
Thank you, Lucy, and we're conscious of the time, but we do have one question, and then we will close.
Hi, I'm Arijit, and I did have a question about the Working Group 3. They have been deliberating about an advisory center in the recent edition at Vienna. And is it better now? Yeah. It's about the Working Group 3. Since you mentioned, Ms. Winnington mentioned about the concerns multilateral investment court may have about political influence, would an advisory center be a better alternative since it has relatively more members? It would potentially prevent a dispute from going before an ICSID tribunal or as the case may be. So I'd love to hear your thoughts on that. Thank you.
I think there are definitely benefits to an advisory centre. I personally think that, mediation and attempts to, settle disputes before they even get to a tribunal is something that's really underutilised in investment treaty arbitration. I think that the problem is that often by the time you get to the point of submitting a notice of dispute, and of course most treaties do actually include a provision where you're supposed to spend 3, 6, 9 months trying to reach settlement before you can serve your request for arbitration, the parties' positions are often so entrenched by this point that it's very, very difficult to navigate a route to settlement preventing a dispute. But I absolutely think that an advisory centre could have its uses, and I think I would like to see greater use of mediation in investment treaty arbitration disputes.
Thank you, Lucy, and thank you to all the panelists today, and thank you for a wonderful audience in interactive questions. And that's why, to the person who said that panel discussions on investment treaty arbitrations in India are not relevant, I think we're going to be discussing this for a long while, even if the government continues to terminate and we aren't able to renegotiate. We've done it, it's done. So, well, thank you, everyone.
Thanks so much, everyone.
Hello. Friends, now we come to the dessert of the afternoon, piece de resistance, whatever you call it. It's always a pleasure to listen to Justice Rohinton Nariman. I hardly ever call him Justice, I just do it for a formality. He has one fault. His fault is he cannot be anything other than clear in his thinking. Now, in most of the judgments, whether it be of the Supreme Court or down the level, it's always debatable. Parties can say this means this or something else. But with Justice Rohinton's judgment, there cannot be two views. It's only one way, and that is he has got this ability to dissect the whole thing, make a visceral pronouncement on what it is. You may agree with it, you may disagree with it, but it has only one view. That is the greatness of the judge, the clarity of thought, the clarity of purpose behind it, which is more important. And of course, his judgments are galore. His judgments on various subjects have been read, followed, maybe criticized also. But in the field of arbitration with which we are concerned, he has been like Sir Francis Dragon, killing all the dragons that come in the way and illuminating the darkness that was there in the jungle, that was the growth that had taken place in Indian arbitration jurisprudence. Ladies and gentlemen, I have great pleasure in presenting to you Justice Nariman, who will now deliver the well-awaited keynote address to this session. Mr. Nariman.
Justice Sri Krishna, can you all hear me? Yeah. Dignitaries from all over the world, ladies and gentlemen, I have been in a state of bliss for the last 2.5 years since I retired from the Supreme Court. Justice Sri Krishna will tell you that the imprisonment is not simple, it is rigorous. And once we are out of that great institution, that bliss rarely gets disturbed, except when sometimes I'm asked to give speeches like this, because it takes you back to your good old or bad old days when you were so flooded with work that there was very little else that you could do. In order to speak to you today, I have actually gone through a large number of judgments in various jurisdictions, all from the last year or 2 years, and ultimately decided to focus on 2 judgments, both of the Singapore Court of Appeal. One of which is the celebrated Republic of India versus Deutsche Telekom judgment, and the other, which is Anupam Mittal versus Westbridge Ventures. And why I have done this is because they raise certain issues with the New York Convention with multiple views, and I thought that I would give you my view on each of the subjects that was discussed. In the first judgment, the vexed issue before the court was whether an enforcing or an enforcement court is bound by what is held in the seat court in a situation where an award is upheld. Because situations where the award is upheld and where it is set aside do somehow lead to different results in different jurisdictions. And we'll have to address that. The facts of this case were that we had a company that was set up in India called Devas. And it was set up by some Americans who had bought spectrum, a whole lot of satellite spectrum from the government of India, its arm being Antrix. Now, this was done in 2005, but in 2011, the government decided to get out of this agreement and repudiated it. There were many like Deutsche Telekom who had actually invested in Devas as a result of this agreement. And they had done so in pursuance of a bilateral treaty between Germany and India. Now, the moment this repudiation took place, Deutsche Telekom went to arbitration in Switzerland saying that what you have done is you have breached this bilateral treaty and I have suffered damage. The Swiss arbitrators first held by an interim award that they had jurisdiction, that sovereign immunity that was claimed by India was turned down, And finally, they also turned down a large number of pleas based on fraud. Because in India, there were two proceedings between Davis and Antrix. One proceeding was a winding up proceeding, which actually ended up winding up Davis, in which certain observations of fraud were made. And the other was an ICC arbitration, which was an award in favor of Davis, but ultimately set aside by the Indian courts, also on the ground of a fraud having been played on the government of India. Now, the plea was that Deutsche Telekom had invested knowing about this fraud, which was turned down by the Swiss courts. When enforcement proceedings were started in Singapore, the first question that was raised by the court was as to whether something like issue estoppel or primacy to be given to the seat court could arise in such situations. And mind you, the situation here was a situation not of setting aside, but of upholding the award. And they ultimately found, yes, it is grounded in the New York Convention. If you have a brief recap of Article 5 of the New York Convention at this stage, it will be useful. Because Article 5 essentially gives you grounds to resist enforcement and says these are the only grounds. It's important that you underline the word only. And also that you underline the word may. A lot turns on it. Does may have a discretion? Does it not have a discretion? And the grounds essentially relate to either jurisdictional or natural justice issues. They do not relate to a review on merits. It's the fifth ground with which we are directly concerned here. And the fifth ground says that where an award has been set aside in the country in which it was made or suspended or not yet become binding, even then, naturally, recognition and enforcement ought to be refused. Now, the moment it says this, the pro-enforcement bias, if I may call it that, of the New York Convention gives way to two other important principles: party autonomy and the other principle of committee. Because the moment another court's jurisdiction, which, by the way, the parties have chosen, because the moment they choose seat, they've chosen the entire challenge procedure as well before those courts. The moment they do that and the award is set aside, then out goes the pro-enforcement bias and in comes in these two principles, as opposed to the rule of law in the enforcement country principle. Article 6 also then tells us that it is possible to go ahead and enforce an award where somebody is trying to challenge it and the challenge hasn't yet got off the ground. Of course, on payment of, on terms as to security, etc. And Article 7, which is also important, says that nothing in the foregoing will ever come in the way of a person trying to enforce an award if he is given certain additional grounds in the country of enforcement. Now, putting all this together, where does issue estoppel fit in this scheme? Issue estoppel, as a matter of fact, arises directly from committee, because what you are saying by issue estoppel is that if, as a matter of fact, all the parameters of issue estoppel apply, which is that you have a final and binding judgment by a competent court of jurisdiction on the same subject matter between the same parties and not subject to the defenses under 5, then you will go ahead and immediately resist enforcement if it happens to be an award which is set aside. Now, issue estoppel, therefore, could be said to arise from the set-aside clause. It could also be said to apply because of Article 7. Now, Article 7, as I told you, preserves certain rights to persons who wish to enforce. So, if the setting-aside court has in fact endorsed the award, and that endorsement is something which is allowed under the law of that land, then, of course, completely, as I told you, different considerations arise. Now, you can also have three situations in which this happens. You can have the situation which arose in Deutsche Telekom, which is that the seat court judgment comes first and issue estoppel is applied by the enforcement court. You can have another situation where there is another enforcement court which has held something, and when the matter goes to yet another enforcement court, the first enforcement court also then is applied to issue estoppel. You can also have a converse situation in which you can first have, as a matter of fact, the judgment of the enforcement court followed by the judgment of the seat court. And if it's the other way around, does issue estoppel at all apply is one question and one conundrum which arises. Now, so far as the first situation is concerned, which was the situation in Deutsche Telekom, the court had no difficulty in following two UK judgments. The judgment in Min Metals, Germany, which was a judgment of 1999, which said that there is a strong policy which favors the following of what is said by a seat court. And absent exceptional circumstances, you will naturally give effect to what that seat court says. The same was held in a 2020 judgment in Karpatsky, with two interesting refinements. One refinement being that the issue need not be identical, it needs only to be substantially similar. And of course, after the issue is substantially similar, you may apply what is called the Henderson exception. Now, Henderson was an 1847 judgment, and it said that it's an abuse of process to allow somebody to raise something afresh in the second court, which wasn't raised in the first instance. Instances of the second situation are in Dia-Human, which again is a judgment of the UK court, which followed an Austrian enforcement court's judgment in order to have issue estoppel apply, so far as a certain award given in Czechoslovakia was concerned, saying that the award had not yet become final. So it did not apply its own mind. It ultimately said this has already been held by Austria. Parties are stopped now from raising this here, of course, subject to exceptional circumstances. The third interesting situation is the situation in Dallas case versus the government of Pakistan, where the reverse occurred. Enforcement occurred first in the UK. And the simple question was as to whether the government of Pakistan was in fact a party to the arbitration agreement, because some Hajj committee was in fact the nominated party. And the question was as to whether that Hajj committee was an arm of government or wasn't. Now, the English courts held it wasn't, and therefore refused to enforce the award. However, it went to France thereafter, which was the court of the seat. And the court of the seat held the exact opposite and said on the same facts that we are very sorry, as a matter of fact, our French code is extremely limited. Our code has item 1520 in it. Either the award fits the parameters of 1520 or it doesn't, which is a really almost an ostrich-like approach, which ignores the court which is supposed to correct the award altogether. Now, apart from issue estoppel being held to apply, the court also went into whether there is something like a prefatory or a preferable jurisdiction insofar as the seat court is concerned. So do you have what is called a primary jurisdiction and a secondary jurisdiction, or do you not? And the court, though it said that we don't really want to get into this, went on to say that yes, it would apply. And the seat court, being the primary court as recognized under Article 5, would really be given primacy over other jurisdictions and therefore would have to be followed. And in doing so, it applied US authorities and Australian authorities. Justice Mance, who concurred with the ultimate finding so far as issue estoppel was concerned, said I don't think we should venture forward into this primacy principle at all. Issue estoppel is a flexible tool. It's a tool based on justice. Exceptions are also based on justice. And the primacy rule, though it raises only a presumption, is not a rule you can really ground in Article 5, because Article 5 only refers to setting aside, which is not a situation which has occurred here. The situation before us, that is before the Singapore court, was the converse situation where the award had been upheld. And if that is so, how do you accord primacy when 5 does not apply, which speaks of setting aside? When we come to an award which is set aside, we have other complications which arise. Now, you can have, again, 3 types of cases. You can have a case where the grounds are so narrow, as in France, that your grounds are even narrower than the 5 grounds or 4 grounds in Article 5 of the New York Convention. You can have a situation where you have an Indian Act where the grounds are almost repeated verbatim in our Section 34 and our Section 48. Or you can have jurisdictions like the UK where, for example, you can actually set aside an award on a question of law, which is really a question then that relates to merits. Do different results obtain because of the kind of setting aside laws that each jurisdiction has? Is again a vexed question. France and Belgium have taken the view that they will look only to their own law, and their law being extremely restricted would have most awards pass muster straight away and would ignore almost completely the court that set aside that award. The only time that they would have recourse to the judgment setting aside would be in their felicitous expression used, that when the arbitration happens to be an integrated part of that legal system. Now, integrated part again is a very loose expression, probably refers to arbitrations which are either compulsory or arbitrations which emanate from court proceedings, perhaps both, I don't know. But the French system, which is ostrich-like, does not have regard to the setting aside judgment almost completely, except in this one exceptional case. You then have other jurisdictions like the UK, Holland, etc., all of which say that we must enforce the judgment setting aside the award unless it is contrary to the public policy of our country. Now, that public policy again can be expanded or reduced depending on whether they are referring to due process and bias, which are really natural justice grounds, or depending upon whether their public policy, as was held in the US, is that there ought not to be a review on merits at all. Now, you can have a situation where, for example, you have a UK court which holds on a question of law that the award should be set aside. In the United States, the approach would have been that, yes, we would have enforced that award, and we would have, unfortunately, we cannot now enforce any setting aside for the reason that it would be against the public policy of the US to have something set aside only on a ground of law, which is a review on merits, and which we will not therefore get into. So we have various views of opinion so far as setting aside is concerned. Of course, one extreme opinion again is that you can have a situation where a court says, as in Luxembourg, for example, that an award that is set aside has no legal existence at all. Now, that would be plainly incorrect according to me, because if you see the language of Article 5 and Article 6, an award that is suspended is put on the same footing as an award that is set aside. And an award that is suspended certainly has a legal existence. That, coupled with the discretionary may that is used, would show that yes, in most cases, you would certainly enforce the setting aside judgment, but there may be exceptional circumstances in which you would not. I would really, at the end of all this, say that the British approach seems to be the most correct. One, it is grounded in the principles of committee and party autonomy, as I told you. The rule of law of a particular enforcement country should not or could not be able to trump these, because this is the competing area. And of course, if the rule of law is to trump these, then the situation should be so exceptional as to almost say that there is no judgment worthy of the name. There's no judgment, as a matter of fact. Either there is such perverse reasoning as to lead to a conclusion that there is bias in favor of the person who has actually approached the courts there, or some other situation in which you would say that the judgment is not a judgment at all, but almost an administrative decision. So I would really say that it is important not to follow the French approach, not to follow the other extreme, the American approach, because under the American approach, you are not giving effect to party autonomy, where parties have agreed that they will ultimately be subject to the courts of that jurisdiction and the law of that jurisdiction, which includes, for example, a limited review on merits, maybe on a question of law. So finally, I feel that it is important to go by the median or the thing in between, which is that, yes, of course, the moment the convention says an award that is set aside cannot be given effect to, you must give effect to that, save and except in these one or two exceptional circumstances, because the pro-enforcement bias now gets turned on its head. And once the award is set aside, we have committee, and as I told you, party autonomy versus the rule of law. So this deals with the first interesting Singaporean. So far as the second is concerned, that also raised very interesting questions. In that case, the appellant was a shareholder of an Indian company. He was an Indian shareholder of an Indian company. And the respondent, Westbridge, was a Mauritian company who invested in this Indian company by purchasing shares. There was a shareholders' agreement between two groups. The appellant had various cousins who he alleged went over to the Westbridge group. But what is important to note is that the shareholders' agreement was an agreement which said that you will have an IPO within 5 years. Now, an IPO is a limited initial public offer. And if you don't have that IPO, Westbridge is at liberty then to walk out. And when it walks out, what it can do is to foist somebody in its place, which foisting has to be accepted by these shareholders. Save and except if that person happens to be a competitor. So when disputes arose, the appellant was ousted as managing director and alleged that the person that they sought to bring was really a competitor. The first shot was fired in the NCLT here, which is the tribunal which looks into company disputes. And he filed what is called an oppression and mismanagement petition. Now, this really has its genesis in English law. Section 210 of the Companies Act of 1948 in England codified an equity principle, which was that if one shareholder or director behaves harshly in a burdensome manner or wrongly to another, then a company court could give relief. Now, in India, it is settled law that for at least 3 reasons, such disputes cannot be arbitrated. The first reason is that when you file what is called a Section 241 petition before the tribunal, you have to show the tribunal that the company ought to first be wound up. Nobody can decide that a company should be wound up except the company court. Reason 1. Second, but to wind up the company would unfairly prejudice some members, which is why you're not winding it up. And you're giving various very, very wide reliefs which can be given to avert the oppression or mismanagement that is alleged. Also, a threshold limit of 10% is given. Now, you cannot approach the tribunal unless you are a 10% shareholder at least. So, the agreement that was entered into, we had a clause 20. And that clause 20 was a clause which was drafted somehow to get over Indian law. And the clause 20 said that if there are management disputes specifically, first you will undergo a mediation process. If that fails, you will undergo arbitration. But not arbitration in India because that would be prohibited. You will undergo arbitration in Singapore. Now, Singapore was chosen as a neutral venue. Singapore had nothing whatsoever to do with the parties or the transaction. Don't forget, even the foreign party was a Mauritian company. So, in this situation, once the NCLT proceeding had been filed in India, the counterblast was a proceeding by Westbridge in Singapore stating that an anti-suit injunction should be granted immediately. And an ex parte anti-suit injunction was granted from proceeding with the Indian proceeding. The reason being that the appellant, by going to the NCLT, had breached his agreement. Now, in this situation, the appellant counterfired by going back to the Bombay High Court now and saying that this anti-suit injunction should itself be injuncted, so that we have now 3 proceedings. The first court in Singapore held yes, we grant the anti-suit injunction and gave various reasons for granting. The Court of Appeal first went into the vexed question as to what exactly would be the law that would apply to the arbitration agreement. Because the law that applied to the contract itself was Indian law. Everything was Indian, short of Singapore being the arbitration seat. And after deliberating on this issue, the court came to the conclusion that yes, following Salar Markia, that you do, if no actual law is indicated by the agreement, which it found, yes, there was no actual law indicated, then you go by what the contract law is, which would have been Indian law. But then you specifically crafted this agreement to get out of Indian. And therefore it can't be Indian law. So therefore, as a process ultimately of inductive reasoning, it had to be Singapore. Now, I am a little surprised that nobody argued, and therefore you can't really fault the Singapore court. Nobody argued that this kind of dispute is not arbitrable according to Indian law. There is a Mauritian shareholder who has subjected himself to Indian law because he's purchased shares in India. So the fact that the company is a Mauritian company is irrelevant. It's like any other Indian purchasing a share. And that this kind of thing could really be decided as a matter of committee only by the courts in India. Anyway, since this was not argued, and what was argued before the court was what is the correct law that would apply. Unfortunately, the appellant only argued that the correct law that would apply to the arbitration agreement is Indian law, instead of saying that the agreement itself is bad and void. Led to a result which was probably correct in law, that yes, the Singapore law would apply. Then when it came to the actual anti-suit injunction being granted, Vijay Karya's judgment was cited. Now, Vijay Karya had said that under Section 48 of the Indian Act, if there is something which is contrary to the public policy of this country, as opposed to something which could be waived between the parties, then there is no discretion. The courts enforcing would have no discretion and could not possibly enforce an award which was contrary to the public policy contained in Section 241 of the Companies Act. The Court of Appeal in Singapore said, yes, this appears to be correct. The respondent has not been able to distinguish this judgment. But then goes on to say, however, at this point, it is too speculative to say as to whether, finally, this result alone will obtain in India. First. Second, it also goes on to say that the Bombay High Court proceedings have not yielded anything for a period of 1 year. And therefore, it would be very difficult for us to ignore this fact. What was, however, ignored was the fact that there was an NCLT proceeding that was pending, in which all these disputes would be decided, according to Indian. And then another piece of reasoning was that the parties will be able to test their relevance, their strengths and weaknesses. But then the immediate answer would be yes, but at what cost and for what purpose? And fourth, res judicata may obtain once the award is given in Singapore. And since it may obtain again, we will grant an anti-suit injunction. Now, res judicata can never obtain for the simple reason that an Indian court, while enforcing, would apply Indian public policy and not Singapore public policy, under which such an agreement may well be valid. The subject matter, therefore, is not the same in law. But given all this, I would still state that the judgment, apart from the reasoning on facts, is otherwise well reasoned in coming to the conclusion that Singapore law would apply. The only problem was the very first important argument that should have been taken was not taken. Having done with these two judgments, I can only end by now saying that in this court also, or in this country also, the courts, by and large, at least at the higher levels, and certainly at the Supreme Court level, do what the Singapore courts did. That is, they look at the convention closely, they reason on the convention closely, they look at other countries' views on the convention, and then arrive at their result in law and on facts. The only problem is the time taken. Now, I have been suggesting for many years, but they've amended the act n number of times, but they don't seem to take seriously the suggestion that the single judge state should be removed altogether. There should be no single judge. When you challenge an award, you go straight to a division bench. And the division bench, again, should be a specialized division bench dealing with these matters, which are then taken up expeditiously and disposed of. Because once this is done, this place will really become a hub for international arbitration. Otherwise, everything else is there. Thank you all very much.
That, friends, was Justice Nariman expounding on two vexatious decisions whose complications he has in his inimitable style narrated for us. And looking at the number of people in this, it reminds me of, as students, we used to go to the most favored professor's lectures, whether he used to know the subject or whether you're a student of the subject or not. This is precisely what happens whenever Justice Nariman lectures. Whether you know the subject or not, you come out of the lecture room somewhat wiser than you were. And look at it, not a single scrap of paper in his hand. Kudos to Justice Nariman. If we had more professors of this caliber, if we had more judges of this caliber, we would be a hub to everything in the world. Thank you very much.